Assalamualaikum, my name is Fatin Maisara binti Ahmad Safri. So today I will be presenting a defamation case titled Stephanie Clifford and Donald J. Trump. This case was held in United States District Court, Central District of California. Stormy Daniels' libel lawsuit over a tweet by Donald Trump accusing her of a total con job was thrown out by a judge who said the president was engaging in free speech. Ms. Clifford, a citizen of state of Texas, brings this defamation action against Mr. Trump, a citizen of the state of New York. The adult film star, whose real name is Stephanie Clifford, alleged that in 2011, after agreeing to speak to a magazine about her relationship with Trump, a man approached Ms. Clifford in a parking lot who threatened that she had better leave Trump alone. Forget the story in Las Vegas, Nevada. After Trump's election to the presidency on April 2018, her team had a forensic artist create a sketch of this man, which was released to the public. The following day, on 18th of April 2018, from his personal Twitter account, Trump tweeted a sketch years later about a non-existent man, a total con job, playing the fake news for fools, but they know it. Clifford's lawsuit alleged that President Trump's tweet was defamatory. In part, she claimed that the tweet claimed that she was a liar, that she could not be trusted, and that she had invented the story about being threatened. She also claimed that it had been published with actual malice because, as she further alleged, either Trump knew about the man that threatened her, either because he or his attorney, Michael Cohen, had directed him to make the threat, or alternatively, Trump had acted with reckless disregard for the truth because he could not have known what had happened to Clifford in parking lot in 2011. Finally, Ms. Clifford contends that she suffered damages as a result of the tweet because Mr. Trump's statement exposed her to hatred, contempt, ridicule, and shame, and discouraged others from associating or dealing with her. In response to Clifford's lawsuit, the president brought the instant special motion to dismiss or strike plaintiff's complaint. Trump argues that Ms. Clifford's lawsuit is a strategic lawsuit against public participation, or SLAPP, and an alternative motion to dismiss. The California anti-SLAPP law was enacted to protect the petition and free speech rights of all Californians. In Texas, the law that protects people from SLAPP lawsuits is called the Texas Citizens Participation Act, TCPA, found in Chapter 27 of the Texas Civil Practice and Remedies Code. The California District Court stated that a special motion to dismiss under an anti-SLAPP statute is to be treated as analogs to a motion to dismiss under Federal Rules of Civil Procedure 12 subsection B subsection 6 applied the substantive requirements of the applicable anti-SLAPP statute and granted the special motion. The alternative motion to dismiss was denied as being moot given the decision in the special motion. Significantly, Clifford was not given leave to amend her complaint, effectively ending her lawsuit barring a successful appeal of the decision. Here, Mr. Trump's special motion is analogous to a motion to dismiss because it makes three main arguments, all of which assumes the truth of the allegation in the complaint and asks this court to dismiss plaintiff's action because these facts do not sustain a cause of action for defamation. First, the defendant argues that although plaintiff alleged that the president made a defamatory statement in a tweet, the statement as alleged in the complaint is a constitutionally protected opinion. Second, the defendant argues that plaintiff has not sufficiently alleged damages as a result of Mr. Trump's proposed defamation because the damages that she suffered could have arisen from the alternate cause. Third, the defendant argues that plaintiff has not alleged sufficient facts to show that Mr. Trump acted with actual malice or reckless disregard for the truth, aside from plaintiff's conclusory statement that Mr. Trump had knowledge of the threat that plaintiff received in 2011. Each of these arguments largely assume the truth of that complaint, but nevertheless make the point that the complaint does not allege sufficient facts to meet each prong of the defamation standard. After a discussion, the court determined that Texas law was applicable, which is where Clifford is domiciled, because Ms. Clifford brought this diversity action in the Southern District of New York, and a state court in New York would apply the TCPA to this case. TCPA is the anti-SLAPP law. Plaintiff's defamation lawsuit actually relates to defendant's right of free speech. Under Texas law, the court have defined the exercise of the right of free speech as a communication relating to a matter of public concern. For a defendant to avail themselves of the Texas anti-SLAPP motion legislation, they must demonstrate that the defamation alleged concerned the defendant's exercise of free speech. Once that established, the burden switches to the plaintiff, who must establish by clear and specific evidence a prima facie case for each essential element of the claim. Having crossed this threshold, the California District Court then moved to the substantive analysis of whether Clifford had established a prima facie case for each element of her defamation claim. Under Texas law, and generally, the elements required to support a cause of action for defamation require: first, publication of a false statement; second, defamatory of plaintiff; third, the requisite degree of fault regarding the truth of the statement; and fourth, damages. In this case, plaintiff fails to establish a prima facie case for defamation. In the special motion, Mr. Trump argues that the tweet at issue is a non-actionable opinion, not a statement of fact about Ms. Clifford. Expressions of opinion may be derogatory and disparaging. Nevertheless, they are protected by the First Amendment of the United States Constitution and by Article 1, Section 8 of the Texas Constitution. The court agrees with Mr. Trump's argument because the tweet in question constitutes rhetorical hyperbole, normally associated with politics and public discourse in the United States. The First Amendment protects this type of rhetorical statement. The court also referred to three principles laid out in Milkovic and Bentley, which is Texas case in 2002, which are that in order to be defamatory, statements in the context of public discourse, first, must be provable as false; second, must be reasonably be interpreted as stating actual facts; three, must be made with knowledge or reckless disregard of their falsity. The court quite easily found that the plaintiff had satisfied the first principle and noted that the president's tweet contained verifiably true or false statements. These were that Clifford was a liar about the alleged threat and her alleged affair with the president, both because the president claimed that the man who allegedly threatened Clifford did not exist and that Clifford was engaged in a con job. However, the court next found that the plaintiff's claim fell apart when examining the second set of Bentley or Milkovic principles. The court noted that a statement that is pointed, exaggerated, and heavily laden with emotional rhetoric and moral outrage cannot constitute a defamatory statement. The court concluded that Trump's tweet, being rhetoric and hyperbole, could not be reasonably understood as stating an actual fact. Thus, the court pushed the Trump tweet into safe haven category of rhetoric and hyperbole in order to tip the scale of finding that it was First Amendment protected speech. In its decision, the court sided with Mr. Trump's lawyer argument that the tweet included an opinion which the president was free to express and the president's tweet into protected First Amendment speech. Any plain analysis of the statements and their context, both general and broad, leads to the reasonable interpretation that President Trump was calling Clifford a liar, plain and simple. The court denies plaintiff leave to amend the complaint. However, in my point of view, this case, the court seemingly pushed the tweeted statements into protected status quite too far under the rhetorical hyperbole, because it involves presidential politics. That is all from me. Thanks for watching. Bye!